fourth case on this morning's docket. That is case number 105982, State of Kansas v. Boozer.
May it please the Court, Meryl Carter-Almond, Capital Appellate Defender, on behalf of Mr. Boozer, and Chief Justice, if I could please have 4 minutes for rebuttal.
4 minutes is granted.
Thank you. Having sat through the previous 2 arguments, obviously I don't want to repeat them. I did want to address it. I heard it from both sides of the bench in the first argument. I think what Justice Johnson said about Smith versus Doe and how do we deal with that as precedent, I think you're exactly right on. It's precedent. We have to deal with it. And how we deal with it is by distinguishing it. The statute, as I've set out in my brief, that the Supreme Court considered in Smith v. Doe is a almost completely different world than the statute that we have today. Also, I think you can look at the fact, and I think Chief Justice John Roberts is probably a lost cause. I'll concede that. Not into reading the tea leaves of Supreme Court justices, but that was a close decision even under the more lenient registration statute. It was 6-3, almost 5-4. So it was a close call even then, and that's without all of the additional penalties that the 2011 amendments specifically have added. Also, I think we can look at, and I 609 this case several months ago, I think the Oklahoma Supreme Court, and I understand that the Oklahoma Supreme Court decided that their law could not be applied retroactively. I understand that was a decision under the Oklahoma State Constitution. I understand the difference there, but the language of
huge difference. They can decide what their own Constitution says, but they can't decide what the U.S. Constitution says, contrary to the U.S. Supreme Court.
And that's absolutely true, but I think the language of the 2 ex post facto provisions is almost identical. I think that they were looking at a statute that is actually, other than the big difference I can find between the Oklahoma and the Kansas statutes is it appears that Oklahoma has some residency requirements. You can't live within so many feet of a school, things like that. That seems to be the big difference. Otherwise, we seem to be talking about the same thing. So it's identical language, regardless, that they were interpreting, and it's an almost identical statute. Whereas in Smith v. Doe, and I understand that, precedent issues here that are at work, the court was considering a completely different statute. And I think that this court can take notice of that fact. And again, as I said, it was a close call even then.
But isn't that residency requirement pretty big?
It is.
That seems like a weighty stone on the scale as we weigh factors.
I think it certainly is. I don't think it was the only thing that the Oklahoma Supreme Court was looking at. They were also looking at the driver's license restrictions, which Kansas has sort of similar. Driver's license and identification card is the main thing that gets branded with sex offender. As I understand the driver's license, it's a little bit more covert. And I don't know, and I couldn't figure it out from reading the Oklahoma opinion, whether Oklahoma has a fee, which, as we've discussed today, the Alaska statute did not have a fee. And I think that's, and I think, and I've skimmed the state's briefs in the other cases at least, it really, because of the procedural posture, didn't necessarily get briefed a whole lot by the state in this case, just because of the way it came through, I understand. But I think individual pieces of this have been said to be okay. But if you look at the act as a whole, that's where I think we get into the punitive territory. And I think the fee, as it plays into that, there's evidence in the record in this case that even before he went to prison, for my client, a really good job was $10 an hour. So up to $240 a year in fees, and that's if he doesn't try to move, is huge. As far as I know, standing here today on my last contact with my client, he's not transient. He has a home. But when you look at transient registration, which is every 30 days or as otherwise directed by law enforcement, which could be much more than 30 days. I mean, these aren't small intrusions into these people's lives that we were talking about. This is a huge burden. I know I've seen cases, I'm sure this court is going to be seeing them soon if they're not already, where people are pleading to more severe crimes than they would to avoid the registration requirement. I know cases where attorneys are desperately trying to get their clients pleased because clients can't comply with the registration because it's so complicated and complex. And if you don't dot one I or cross one T, then you're looking at a severity level up to a severity level 3 person felony, where the crime in this case was a severity level 5 felony.
Let me ask you about the fee, because I'm mulling that over, but isn't the measuring stick on the fee, whether it's related reasonably to the cost involved, that was what would tip it over to be a fine rather than a fee? And I don't see any evidence of that in any of these cases about what it might cost to have one of these notification programs.
I don't think that's in the record. Certainly not in the record in my case.
But wouldn't you agree that, I mean, the case law seems to say that's the measuring stick. It's the cost of the program that has a public purpose, rather than the burden on a particular defendant.
I mean, and again, if we break this down into individual pieces, the $20 fee by itself, maybe not that big of a deal. The in-person reporting, which, as we've discussed today, Alaska didn't have when the Supreme Court decided that case, maybe not that big of a deal. It's the whole package together that is a huge burden and becomes punitive. I mean, and that's basically my argument. We could, I think, in the other cases more so, the state picked apart, this has been said to be okay, this has been said to be okay. That wasn't really done here. But I think it's when you look at the whole package that it really becomes problematic.
Do we have any law with respect to, say, lab cost? The defendant that's ordered to pay fine and costs, and the cost will include a KBI lab fee. Do we have any law that says that's not punitive because it just simply covers the cost?
Not that I'm aware of. I'm a lot more aware of as it relates to attorney's fees. And obviously those are waived for indigent defendants regularly. And there is a provision actually for indigency in the KORA statute, but it doesn't, the way it's written, it doesn't seem to help a lot of clients because it requires, as I'm reading the statute, it requires the finding of indigency to have been made before by a court somewhere. So it's worded oddly, so it doesn't seem like it really would catch very many clients, I guess, many defendants.
Any further presentation?
I think that if there are no more questions, that's all I have.
More questions? Thank you, counsel.
Thank you.
I'm Mark Noah. I'm the Mitchell County Attorney, and I'm here for the Attorney General, State of Kansas. So I was looking over this case. I kind of look at our Court of Appeals decision, which remanded the case so that the defendant could be re-notified of his duration of registration. There has been no hearing to do a re-notification. The district court made a lifetime registration requirement that was wrong. Should have been 10. Going back and doing it right would require the court to give the notification on registration for 25 years. That has not been done. The court at that time could very easily determine whether or not Mr. Boozer was indigent or not at that time.
But it couldn't change the length. the court doesn't have discretion to do anything less than 25 years.
That's correct.
And isn't that different than Alaska? Wasn't there a opportunity in Alaska to obtain a modification if you could show that it was no longer needed?
I don't recall. There may have been.
But that does impact whether it's punitive, don't you agree that the fact that it's mandatory and there is no individualized assessment?
Well, but in this case, the court ordered lifetime registration and then is bringing it back down to something other than lifetime registration, which would be 25 years. There was no objection made to that at sentencing for the lifetime registration. It wasn't brought up until the Court of Appeals heard the case.
So, but the Court of Appeals did address it.
They did. They
So
did.
are you saying that it's not properly before the appellate courts to consider?
I think until it's remanded and the court gives proper notice of the registration requirement, makes a determination of whether or not the defendant can afford the $20 filing fee, and determines any other issues that might be necessary at that time. It's premature to be here. In the Myers case, the court says multiple times in there that Cora, as it applied to Myers, well, there was a record in Myers where statements were made and evidence was taken where Cora did impact him. There is nothing here as to whether or not Mr. Boozer can afford the $20 registration fee or any other factor in there applies. We just don't have it. And until we go back and have a record on that, I think we're here prematurely. I really don't have much more beyond that. You've heard plenty of argument for more complex cases than this one already this morning. I just think we need to go back. The court needs to do it right, give the proper notification of 25 years instead of the lifetime registration, and make a determination whether this young man can pay $20 for registration or not, or whether we're going to have an issue of whether he's going to be in Jewell County, where he's originally from, he's going to be in Mitchell County, or he's going to school in Cloud. All those registration things are important, and that could be brought up as to whether he's indigent enough not to be able to pay those registration fees in those other counties. Without that determination, I don't know how you can make the determination or make a decision as to whether that is punitive or not. But that's all I really have. If you have any questions, I'll be glad to try to answer them.
Any questions? If no further presentation, thank you, counsel.
Thank you.
You're reserved 4 minutes.
Counsel? If I'm understanding your opponent, he's saying not only is this not an ex post facto application, it's not even ripe.
I disagree with that. Perhaps you're not surprised. First of all, just to clarify the record, and this is on page 65 in the sentencing hearing, the only thing that was said about registration at sentencing was the court orders that you will be required to register as an offender pursuant to the Kansas Offender Registration Act. There was nothing said about length of time at sentencing. That was clarified in the journal entry is where that came from. So really the first opportunity Mr. Boozer had to challenge that was his appeal in the Court of Appeals, and that's what we did. And it was challenging to figure out how to bring it up, because when I raised it in the initial brief, I suspected that the state would come back and say, no, it's 20, because we said it's 10 years. I suspected that the state would say, no, it's 25 years. So this is an interesting procedural case in that regard. As far as, my client is being required to register right now. And we don't dispute that he will be required to register for 10 years. So I suppose it may not be ripe in some regard, but I mean, that's almost like saying that, if we're arguing that someone should have a hard 25 sentence instead of a hard 50, that we can't appeal until they're on year 26. I just don't really understand opposing counsel's logic on that. he's being subject to these requirements right now. He's been paroled as of this summer. So I just don't see any issue with regard to ripeness in this case at all.
Any further presentation?
No, mostly I just wanted to clarify the record on what was said as sentencing. So
Any more questions? Thank you, counsel.
thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.